Good morning, everybody. Thank you for joining us today. I'm joined here with Corette Miller and Geeta Leyland, and I'll get into introducing them more in a second. But thank you for joining us for our webinar, Risk Management for Employee Practices Liability. We encourage as many questions as you can think of as we go through this, and I'll remind that again as we go. But let's just dive right into what we're up to today. So first, why do we as an organization put on these webinars? So we do this because we care about your business's success beyond just the insurance solution. And we know if you take preventative measures like what we're going to be talking about today, you can ensure greater chance of success. And we just love introducing you to great people like Corette. Corette did our Bill 148 webinar a little while ago, and it was actually our most popular webinar to date. And the feedback we got on Corette was amazing. So it's just great to be able to bring people like you to our community here. And it's just aligned with our core, our mission statement, what caring insurance brokers do and then some. And this is really the and then some piece. So why is this employee practices liability? Like, why is this such an important topic today? First of all, the actual increase in the cost of claims that our insurers are seeing from companies that are having employee practice lawsuits, employment lawsuits, are actually on a pretty steady increase in rise. Also, about 40%, just over 40% of lawsuits brought against companies, employee related, are for smaller organizations. And so many of the companies that we serve, 100 employees or less, are at most risk, and then the ones who are obviously larger are obviously seeing a lot of it too. But there's nobody that's necessarily safe or it's cracked for. But a lot of smaller organizations in specific really feel like they know their staff, and their staff would never do this to them, and so they make sure they don't take steps towards protecting themselves. And so 7 out of 10 do not actually even have the insurance we're going to talk about today. And then also just on the right side of this slide, you can see the bulk of it is around wrongful dismissal and discrimination, harassment, and humiliation are really the big key areas, as well as severance pay, vacation pay, and making sure people are doing that properly. Interestingly, 6 out of 10 businesses actually believe today that they have coverage inside their insurance for employee practices liability, and they do not. And so it is a pleasure right now to introduce Corette. I've had this opportunity now a couple times here in webinars and outside. Corette has over 15 years experience in the HR profession. And even bigger than that, she is such a contribution to the companies she goes and serves. She really works on not just coming in and being an HR specialist, but really getting involved in the work culture of an organization and making sure that she fits and that she's bringing that forward in what she does. She's worked in organizations from very micro size to large international, and has a whole range of experience and has clients in a lot of different industries that we serve as well. And so it's at this time that I'd like to introduce Corette to everybody.
Good morning, thank you.
And so we're going to start off with the first question, like where do employers most commonly fall down with their employee practices?
I love your slide that showed that 41% is like the smaller organizations, because really that's where we focus on as well too in our support. And that is where employers do mostly fall down, is they're not prepared. They don't have the documentation in place, they don't have tools in place, and they really don't have what they feel, what I always say is needed to support. And that's a big question I get asked when I do different sessions, is like, well, where's the support for us as the employer? The employee has everything under the Employment Standards Act and everything's all highlighted. And to me, it's having your toolkits in place and having your foundation in place. I say that over and over again. You wouldn't build a house without a foundation, right? So you're building a business without a foundation. What's your foundation? Your foundation is having your guidelines in place. So policies and procedures, what your handbook, whatever term and title you want to use for it, but really setting out the terms and conditions of the employment, so the employees know. So you get to set the stage and say, this is how we're going to play in the playground. And also the other most important tool that I would say is having employment agreements and contracts. So, and having those in place, ensuring that the employee has time to read the terms and conditions and are quite aware of it before starting. So I've just recently actually dealt with a lawsuit with a client, and it was one little clause in their contract too that wasn't correct. It was a breach of the code. So it's important to make sure that you've had someone legally look over your employment agreements and your guidelines. But there's also if the best practices is giving the contract at least 7 days, 2 weeks is ideal for the employee to review it, and also a copy of their guidelines and signing it back before they start. So if they sign the contract on the day that they started with you or after, it's an invalid contract. So now you've just lost your best tool, right? Because you said out front, here's all your terms and conditions. Here's, here's our dress code, here's our hours of operation, here's our vacation policy, you highlight all that, and here's our termination clauses, and which is really important, is talking about your termination clauses, and because you want to avoid common law suits, and you want to stick with the ESA requirements, and you do all that, you've done your diligence, and then it's an invalid contract because they signed it on the date. So. And and I've seen that happen over and over and over. So that's a big one. So so I would just say be prepared, make sure, before you hire, as you're starting your company, if you're already in your company and you've got staff, then that's something else that we got to talk about. So.
Okay.
Actually, just a question on that. Would you consider reviewing your contracts after a couple of months or yearly with your employees, just as a refresher?
You could, but the thing is, if you want to ever change someone's contract, there has to be some kind of consideration. So the best time normally is if they're doing a promotion, right? So always do updated paperwork during the promotion. But when I say something in consideration, it's usually financial. So I had a client recently, they wanted to change their non-solicitation clause and non-competes, and they were putting in specific geographical requirements. And so they had to give everybody, they offered $100 for everybody to sign off on the new terms and agreements. So that's something in consideration. So if you've never had agreements in place, and depending on the tenure of the company, the tenure of the employee, how long they've been in that specific position versus another position, there's all kinds of things that you would look at, checklist, to determine how much you would put in consideration to sign off.
Okay.
And I'm just thinking, just on this topic while we're here, like, some small companies hiring their first couple of employees, maybe at the greatest chance of risk, maybe it's that next tier, but small employers, very like micro small, don't necessarily even have that like full throttle employment contract in place.
Yeah, and they really should, because you mentioned it earlier. Everything's good until it's not good.
Yeah, you think you're like even hiring, I'm hiring a friend or somebody that I really trust.
Yeah, everybody's happy until it's not happy. And the longer, what I see is the smaller companies have longer term employees, right? Where they'll have people, let's say there's only 8 in the office or 5 in the office, and some, they'll have employees that have been there 15, 20 years type of thing. So, and they don't have an employment agreement in place, any terms and conditions. And then now we're at, in the fortunate time that we're departing, and it doesn't go well. Right. It can be quite costly. So.
Okay.
But again, just having everything in place ahead of time, being prepared, taking the time, and if the smaller organizations is just as key, even part-time staff is just as important to have agreements as it is, directors or managers and things like that.
Sure, yeah, I would even imagine, I think we're going to mention this a couple of times later too, smaller employers as well, like, there's a lawyer as a term, and you may have like a corporate lawyer or a contract lawyer or somebody specializing in a certain place, but, most organizations don't necessarily have like an employment law specialized lawyer that they just go to
Mhm.
with questions whenever they have them.
Yeah.
So I know I jumped to this slide, and we spoke a bit about, some proactive risk measures, but what other kind of proactive and reactive risk measures do you see?
Well, I told us about, creating your foundation, and document, like have everything documented as much as possible. So, when I say that, I'm thinking about, the risk management. If there are situations in your workplace, with an employee specifically, you want to document as much as possible. Again, people are like, oh, well, I had a conversation. Okay, if you had a conversation, document that conversation as well, that you've had a conversation. So also, I have here posting legal requirements. There's a lot of, that's a simple, easy way to be proactive, that you reduce some of your risk in an organization by posting. There's two or three different posters, the ESA poster, health and safety awareness poster, and WSIB poster if you're a member with WSIB, Workplace Insurance Board. And then posting some policies are required by law as well. Harassment and discrimination and health and safety policy needs to be posted. That's an easy, proactive thing that you can do, and because if administrative labor comes in, that's a quick $500 fine.
Okay.
Right? So, and that's what they'll do. They'll come right to your health and safety board, and they're going to look for those 3 or 4 items right away, and plus the little green book. And if it's not up there, this is an immediate $500 for them.
Wow.
So that's that's an easy proactive risk management on some of the legal aspects of things. So yeah. So yeah, post your guidelines, and then conversations. I know we're going to talk about some other issues, and that but having conversations, like open, honest conversations with people. It's something I try and encourage with clients a lot. Just if someone's doing great, let them know they're doing great. If someone needs an area of improvement, let them know they have an area of improvement. To say, hey, you're doing all great here, but I need to see improvement on this place. And usually having that dialogue with each other can reduce and mitigate any issue blowing up.
Yes,
right?
down the road.
Yeah, exactly. I just find that in individuals, we have a hard time talking with each other.
Sure.
Right. So
The hard conversations
Yeah.
are very difficult to have.
yeah, and it's it's just having a direct, open, honest conversation can reduce your risk as well.
And then on that, the positive and the constructive feedback, and I know the constructive side is usually where things can get more challenging.
Yeah.
So in that, you pass and by talking to Gita, and I can give her something constructive and positive feedback, but I should make sure I always document this, or is that required as much as possible? Like,
Yeah,
what?
I always document. So if you're just having your first verbal conversation, I always say you have your own little manager notebook, right?
Okay.
And you would keep a little note in your notebook saying, had this conversation, on March 15th, blah, 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 blah. And then, July comes along and the same issue pops up. So now you're having another conversation again. And then maybe 2 weeks another. Now you're going to go back and have more of a formal and highlight it and say, hey, in March we talked on this time, in July we talked, and now here we are again at the end of July, and we're having the same conversation, right?
Okay.
So you would have forgotten about that March conversation, or you would remember it, but because you documented, you can be very specific.
Right.
So, so the more you document and you have the specifics, the more now this is your tool as an organization to say, hey, we did our conversations. So, and when you're having your documentation and your conversations, what the ministry will always look at, the courts will look at, and lawyers and mitigators and stuff, is did you highlight what the issue was? What's, where, what we need to see. So here is where you're not doing so great. Okay, let's just say it's performance issue. Here's where what we need to see. What's our expectations? And then here's what the consequences are if you don't, and that's the risk of losing your job. Right. And if you're that, and you're like, oh crap, the wording is so horrible. I know it's like, further disciplinary action up to termination without notice.
Yeah.
Without notice is key. It's a very key term there. But using that term, then at any point in time, you know, I've had lawyers call and I've had ministry call me, even unemployment insurance will say, were they aware that they were at risk of losing their job? And I said, yes, here's the documentation. And as if they're aware, you know, then you've done your due diligence as an employer.
Right. So I'm just wondering, for those open conversations where you have that March conversation, should you follow it up with an email or anything afterwards as an employer?
Some do, yeah.
Okay.
And I would say yes or no, depending on the situation, right? Sometimes it might, if it's the first time, if you want to try and keep just in a relaxed relationship and you don't want, you know, you can just do it. But really depending on what the situation is and then who the individual is. So.
Great. And inside of the opposite of, you know, proactive risk management, there's also opportunity to create reactive risk management. And that's really where insurance comes into play. And this is really, again, an insurance coverage that most people just don't even know exists. And so I just really would love the opportunity and pleasure to introduce Keela. Keela. It's full form here. And she is our Director of Commercial Line Insurance here at Bryson Insurance. And she is just a phenomenal resource and a phenomenal leader in our organization. She has a lot of history and background in roles, again, from an international insurance company right down into a local brokerage like us. So she brings many years of wisdom and experience and is really a great role model and mentor. And is personally really passionate about this insurance coverage as well. And so I'm going to jump right into the actual coverage here. And if you want to say anything else that I left out there.
Yeah, no, I just think for me, what most clients need to understand as that this type of insurance actually is an extension of your commercial general liability policy. Your commercial general liability policy excludes this, and most clients feel that that is there. So it is a separate policy that you can purchase, or it can be added on with the directors and officers policy, but not everyone has that policy. So you can purchase this as a standalone policy.
And so, like, what is it?
So basically what it is, so it's an insurance policy that actually pays for defense costs as well as settlement expenses afterwards in the event you are sued for an employment practice liability suit. So that's basically the big bulk of the insurance cost is all related to the expenses. As we know, costs for the lawyers are high, especially when you get specialized lawyers. They can start at maybe $400, $450 an hour. Some policies can start as low as $400. So what you have is expense costs that can range, you know, anywhere between $35,000 to $50,000 before you actually even settle on that claim. And that's what this insurance policy is there for. It's to actually protect you for those defense costs, investigation, any appeal cost, or just basically any settlement cost afterwards.
Okay.
So again, it's part of the toolkit.
Absolutely.
Right, being prepared ahead of time and being proactive.
Absolutely, yeah, and we'll actually get into some case studies where we'll look at this as well. But even the application, and we'll talk about this in a bit as well, has a lot of. It's almost like an opportunity just to go through a checklist to see how am I doing as an organization, and is there gaps that I'm not even aware of that I'm not currently covering. So how does I know you went over a bit of how it works, but how does it actually work?
So in terms of like reporting it to the insurance company, or so?
Yeah. So what happens? So what happens when somebody actually were to go ahead and file a claim, just from a high level, and we get into more detail when we get into the case studies.
No, perfect. So I'm an emotional person. So I've actually had clients call me very upset when they actually get these suits in front of them. And the first thing they start to actually think about is, what do I do? How do I protect myself? You know, do I have the funds to actually go and defend this type of claim? So what you do is basically you would report these claims by either the defense letter that you, or sorry, the settlement or the claims letter, the statement of claim, or even sometimes it's just a verbal notice that you've received from some sort of an employee or person that didn't get promoted. You might have that. Those actually get reported to the brokerage. Once we have that, we send that into the insurance company. If you do have this policy, a claims analyst is then assigned to your account. They will actually review all the documentation that they have. And what I love about it is they actually build this team around you to support you through this whole entire procedure. So these claims can vary in terms of the longevity. It could take a year, it could take up to 5 years. So imagine that time and investment and just even that emotional state that you'd be having to go through. This is where that claims analyst takes that down and says, we're going to assign a specialized lawyer that actually practices employment law. We're then going to start to do some investigation, and then they're actually going to walk you through with all the other information that they would need. So again, it's just that high level support that you would need, and to know that these defense costs, which again are the bulk of the cost of the claims, are being taken care of by the insurance company.
So does that lawyer then support them through the case, or they had to go and get a different
No,
lawyer?
they support them through the entire case, which is a great thing, because then you have that start to finish of that lawyer. Any mediation that needs to occur, that's something that also is arranged for with the claims analyst. So they just take the whole claim and they work through it with you on, maybe it's not we're going to go to court. Maybe we just need an arbitration. Maybe we need a mediation. It just goes from there, and they walk you through that. In some cases, they might say, let me see your entire documentation, and they don't see enough documentation. They might just say to you, let's just settle this claim, offer a settlement, and then talk to your broker on how to get these other policies and procedures in place. But they will walk you through and give you even the best advice on what to do. And then the policy is there to respond.
Document.
Document.
But I have another question.
Absolutely.
Is there ever a chance that the claim can be denied by the insurance company?
I haven't seen a denial as of yet, because the insurance company, basically, they have a right and a duty to defend, which is great. And because again, it puts that onus on at least just defending the claim. Maybe something happened, and maybe some sort of, you weren't following law. I don't know if that would happen, but there's that duty to defend, right? And again, those are the big bulk of the cost. So that's what I've seen. Now, the other thing I have to keep in mind is that some claims actually do come in monetary requirements, or some of them are non-monetary requirements. So based from a claimant that's actually putting that in. So that's something that the insurance company, again, would defend at least. So again, the policy does include the right to and duty to defend.
Okay.
Yeah.
Okay, and when we jump into the actual, you were saying, it could be pretty low cost, but what actually impacts the cost of this type of insurance?
Absolutely. So I know on our screen we have it's the number of employees. You actually have written procedures in place. And again, I love the application because it does point out a few things that you want to make sure you have. Again, it's all written procedures. Do you actually touch upon these pieces of information? Do you have that all available? So again, it's, have you had any claims in the past? Mind you, I know a lot of clients do get afraid if they've had a claim, then that means no one's going to want to insure them. That's not always the case. We all learn sometimes when we have a claim. So if you do have a claim, give us a call. We can always just work through, find out what happened. Again, we always ask, what you have put into place to mitigate any future claims. So again, it's that proactive approach is what we're looking for. And then we can work with the insurance company again, to get you good rates.
So they ask you those questions?
They do. Yeah, they do. It's on the application. So they do ask if you've had any in the past. But again, there's a good section that says if you've had one in the past, just talk to us about it. What happened in that claim? What did you do to mitigate any future claims from occurring again?
So I see in the third bullet there, talking about what I said, that your harassment policies and health and safety policies. So that's a requirement under the Occupational Health and Safety Act. So they're probably bringing in a little, it looks like the application is trying to bring in a little bit, here's what your legal requirements are, and here's what some best practices are.
Absolutely.
That's great.
Yeah.
Okay, and we're gonna jump into case studies in a second, and I just wanted to put this list up here quickly, just so you guys can all have an opportunity to see the different types of wrongful employee practices that pop up most commonly. And I'm not going to necessarily go through this entire list, except for to then jump. But you just give you a second to look at them. Are you just looking at something?
No, I'm looking at them because you know what? I think one of the ones that's here, of course, is this one that everyone kind of forgets. It's that failure to hire. Sometimes you might even get a suit just because you actually didn't hire someone. You hate to have that happen because they haven't even started as an employee. So again, wrongful dismissal, wrongful termination is the biggest one. We all know of all the movements that are going on. So there is an awareness out there too. Again, for me, it is that failure to hire, failure to promote, which is where a lot of companies can get themselves into a lot of trouble.
And they're probably with that, the failure to hire would most likely come in underneath the human rights claim,
Sure.
right? So because they're gonna make a claim, I didn't get hired because I'm this, or I didn't get hired, I didn't get promoted because I'm this. And it's a breach out of the 14 different spots in the Human Rights Code. And it's, common law cases with lawyers for wrongful dismissals are very high, but as with the ESA, they have usually like a guideline to follow. The Human Rights Commission and tribunals can be even more costly. They're the ones that scare me the most when we're looking, if I'm working with a client and they want to consider letting somebody go, you knock off your risks. And the Human Rights Code, Human Rights claim is the one that's most risky to me because they make up their money. They make up their dollar amounts. And there's no nice little charts, right? So you could something very simple can end up costing you $50,000 very quickly. So and I just seen a claim with somebody who'd only been working with the organization for 65 days, and an employer let them go, and they went to the Human Rights Code, and they got a claim payment of $15,000.
Wow.
And that was only after 65 days of working. So that's so failure to hire. Best way is to make sure you have your practices in place, like your procedures, document with the interviewing process. So what you're looking for. That's a session all on its own. Actually, smart hiring. But it's very
Sure, yeah. Smart hiring could be its own weapon.
Yeah, it is.
Actually, I was just going to say on that human tribunal, so I've been on the other end where I had a claim come across my desk and reviewing this report, which can be quite lengthy. A lawyer's cost to review that. I actually had someone send me an invoice because they didn't realize they had a policy. Just to review the document was $4,000 in legal fees. Just to review the document, not even to respond to that document. It's time consuming, absolutely.
A lot of data.
Okay, so let's jump into these case studies, and I'm just going to encourage again to ask questions and jump in. Inside of this, I wanted to bring up this slide again, just so we can see we're really honing in on some of the most common areas that these claims or these suits come in. And so the first case study, and these are very general in nature because they're supposed to create sort of hypothetical conversation and different scenarios that we might have experienced over our past. So first one is a hostile work environment. Allegations were made by an employee that his employer had created a hostile work environment by failing to deal with bullying coworkers. Yes. This is a real this is a real claims example that we have access to. So I mean, this is something that actually happens, and so this claim comes in. But before we would like it to not have any claims, and so we really want to get into the proactive side of the conversation. So what do you see in this that an employer may have been able to do?
Well, it's probably what under the Occupational Health and Safety Act, it's a requirement to have your harassment, discrimination, and non-bullying and non-violence practices in place. So easily a way to be proactive, and again, have your tool as an organization, have your policies in place, so your non-violence, non-bullying policy in place, along with your harassment and discrimination policy posted. But most importantly, you are required by law to do the training. So have an actual, in-class training session done. And you are required, regardless of size, to have the training in place. And if you're 5 or more, you're required to have the policies, the written policy. So regardless of size, you have to do harassment and discrimination and non-bullying training. And 5 or more, you have to have a written policy. So what will happen, why an employee can make allegations of this, is that the employer did not have this in place. So therefore, they weren't compliant. And they didn't tell them that, hey guys, you have to play nice. Right. And really that's what the training is it tells you, what's considered violence and what's not considered violence, and how we have to act within the workplace. So that's where this would have came from. Bullying is not under Human Rights Code. It's under the Occupational Health and Safety Act.
Okay.
So it's in two different spots. And the reason why is a lot of bullying cases went to the Human Rights Code, but when they got very specific and, and said, well, it's not a breach of due to race, it's not a thing due to ethnic background, it's not due to gender, the person is just being a bully, they're just being bullied. So everyone, the lawyers and the tribunals were like, how are we going to deal with this? And that's when they came up with the Bill 168 under the Occupational Health and Safety Act. And it's a requirement actually back in 2010.
Wow.
Oh, wow.
And it's amazing on how so many companies are still not compliant with this.
Sure.
Yeah.
Wow.
And the fines are immense.
Yeah. So yeah, not even if you actually fall into a lawsuit scenario, just the actual fines.
Just the fines themselves. Right now too, and because they're getting pretty stringent, because this has been a law in place for 8 years now. So you're looking at anywhere from 5,000 and up. And
Wow.
I recently read an article that if you actually have an incident on place under Bill 168 where bullying follows, you can end up, the CEO or the owners can receive $500,000 and up to 12 months imprisonment.
Oh my goodness.
Yeah, so it's very serious. And unfortunately, there are a lot of bullying cases in the workplace, but that's the most simplest way to do it. Do your training, have your policies up in place, and then just say, hey, people, this is how we play nice here.
Sure, and I think, and then coming into the actual other side where the insurance comes in, I mean, even before considering that, like, just imagine, so you create a workplace, you can think of it as yourself as either an HR leader or a business owner watching this webinar, and you've never intended to design a workplace where bullying exists.
Yeah.
And all of a sudden, you get handed these papers, and you're now being sued for creating a hostile work environment.
Mm-hmm.
I mean, just think, like, what do you do next, right? Like, what would you actually do next as a business owner inside an organization without having like the resources to actually take that next step while still managing all your other work commitments?
And again, it's going back to where it's saying have conversations. So when people want to avoid it and they think they're avoiding it, they can see it happening and they're thinking they're avoiding it, it's going to go away, and it won't. And it can be something that's very simple, like, I had a situation where, two ladies in the office, friends, just joking around one day, and of course, one girl was teasing her and teased her a little bit too much and embarrassed her. And she had a folder in her hand. She said, "Oh, stop being so silly." And she tapped her on the top of the head with a folder, and a bullying and a violence thing came through. So, and it came down to, again, this organization had no policies in place. They hadn't done any training. They didn't have any awareness. So of course, they were reactive, right? And they got that all in place. And then they had conversations with people afterwards, kind of just saying, this is how we act in the workplace. And so that's a very minor situation, but that's a minor situation that caused so much work, so much time, afterwards, after an operation.
Sure. And then now when those papers actually come in, like so if you had the insurance coverage in place, and this will sound like a bit of a record on repeat, so we won't go through this for each one. But what would actually happen in the case of somebody actually having insurance?
When someone has the insurance, you give us a call. We actually report it to your insurance company. Insurance company assigns a claims analyst that just basically walks you through the whole claim. You then have a dedicated employment practices lawyer actually assigned to your case, and just all that investigation, all that cost, all those resources that you would normally have to actually put up in just defending the claim is actually being put forth by the insurance company. So again, it's that peace of mind that the insurance company is going to be looking after you and guiding you along with the next steps.
Great, thank you. Okay. Jumping into defamation. A senior employee whose employment was terminated sued several directors for defamation following the publication of an all-staff memo describing the details of the termination. And before we started this, we were just joking, like, Brett, have you actually seen these types of things? And she said, yeah.
Still can't believe it was done.
Yes, I've definitely seen this. So this would follow really, it's not a severe breach of an ESA point, for example, right? It may fall a little bit under bullying. It could fall a little bit under human rights. It really depends on, you know, the details in the memo and what's been said. This one would fall more just kind of on some common law practices. So, you know, on your chart, you showed 51% are common law cases. So what is required is an organization, even though when you are, and you've decided someone's terminating and leaving your organization, you are accountable to ensure that you handle the situation with the utmost respect, all the way from the beginning to the end, and also ensuring the privacy of the individual and confidentiality. So describing the termination was probably a breach of not being respectful to the senior employee or any employee really. Doesn't matter your level. So you weren't respectful with that, and then you breached the confidentiality on him. So I could see that lawsuit easily coming forward.
Yeah. Okay.
Yeah, so they do, and you know, it's down to how you have the conversation and how the individual exits your building, how you deal with them afterwards, you know, type of thing, and providing them with support. So that would have been very embarrassing to the individual. So you didn't show your you showed lack of respect, and a lawyer will sue for that. So.
It's funny, I'm looking at this one and thinking that reply all email that went out to staff or went to this staff member and it should have gone to this, and then it escalates from there. So
and inside this too, so you know, because we know there's some companies who actually have this insurance without knowing they have this insurance as well, right? And it can be inside of the directors and officers policy. So I just want you to briefly discuss that too, because this would be a situation where these directors are being sued.
Absolutely. So you want to look at the type of policy for a director and officers. It would include some coverage there to defend wrongful acts actually performed by the directors. If you don't have a directors and officers policy, directors and officers are actually personally liable. So under that directors and officers, you will have a sub-limit for employment practices liability. So again, that limit can be shared, so you want to look at that. And again, it just defends any wrongful acts committed by the corporation, by the directors and officers, and by the managers. And again, it would just be the same thing where the claim gets reported and then the claims analyst is assigned for that under the policy. Which actually, just keeping in mind the one thing that I want to talk about, insured persons, Kyle does make a good point that under the policy, you want to look at who is an insured person. So you want to make sure that includes, you know, your current, your present employees and future directors and officers, your current directors and officers. And also the one thing you want to keep in mind is any volunteer staff, any temporary staff, any seasonal staff. I think, I'm not sure if I'm saying it all, but you know, a lot of companies don't remember these as staff members and actually include them as well. So that's a good thing you want to look at when you're actually talking about your policy that you have. I know I'm going to talk a little differently here, but I just wanted to talk about defense costs. I know we've mentioned that defense costs are the bulk of the cost, but that's one thing you want to look at when you're actually looking at the limit of insurance, because some policies actually, it's the defense costs are included in your limit, which means it erodes your limit of insurance for a settlement cost afterwards. Again, this is very high level. Love to talk more in detail about this one, but yeah, that was just what I needed to point out.
Excellent, yeah. Okay, so we will jump into our next scenario, a discrimination suit. So an organization was faced with a complaint brought under human rights legislation by an employee who alleged that she had been discriminated against based on her race, color, ancestry, and ethnicity.
Yeah. So yeah, that's a breach of the Human Rights Code. So we have a Human Rights Code across Canada, federal, and then of course each province adapts their own. So under the provincial code, those are 4 out of 14 points in the code. So to be proactive. Again, is doing the training that I mentioned earlier, right? So around harassment and discrimination under the Human Rights Code, because there's the two there are 2 trainings under human rights and occupational health and safety of harassment and discrimination. Both follow and both act in the code. So doing that training, so it will be proactive. And then post, so post again is ensuring that's rolled out into the organization. But this could happen, discrimination can happen easily before her employment based on these. And then while she's employed, which this case was based on, it came down to not recognizing for promotions and missed out on career opportunities based on her ethnic background and her race. And unfortunately, even though we're 2018, it happens. And sometimes it's subconscious too. An organization doesn't even realize, or certain leaders don't realize that they're doing it.
Sure.
But that's where this specific case came from. That she was missed out on career opportunity, and where she would have to, she can't just make a claim. Well, she can make a claim, but she has to have something to back it up. And then if, during the whole investigation, they come in and see who is promoted and not promoted and why, she was skipped over, and there was no legitimate reason, like, if we come back to, hey, Kyle, like, sorry, at this point in time, I know you want to move to this position, but we need this experience and this background, and that there was nothing in her performance management to justify that.
Right. So then it just came purely, he said, she said scenario.
Yeah.
And in that side too, like what's just there for me is with the Human Rights Tribunal, there's kind of like employees or ex-employees really have the freedom to just go test with them to see, hey, is this the case? Like, is there something here? And then Human Rights Tribunal covers all that cost, right?
Yep.
And so employees kind of have that freedom to just reach out and say, hey, this is the scenario that I went through. Is there a case here to come against the employer? So like, there's definitely like that trending of increase just because employees have this resource. I just foresee continuing. What were you going to say?
Yeah, and it's true. And the Human Rights Code very much supports the employee. And as an employer, when you call, sometimes they won't answer. They won't answer your questions. They prefer for you to go to a lawyer.
Right.
Yeah. So yeah.
Okay. And I don't know, is there anything that you want to add on this one?
No, I mean, the only thing I can think of is on that human tribunal claim, I've actually seen it where they put in, you need to respond by X amount of time. So the pressure that builds up for clients is enormous during that time. And what do you do? How do you even find an employer lawyer or a lawyer specializing in employment practices in that quick short term? So that's why these policies are great again. But that's a good one.
Okay. And so this is the biggest chunk of that pie, wrongful termination. So a senior executive's employment was terminated after allegations of sexual harassment were made against him by another employee of that same organization. The executive sued his former employer for wrongful termination. So the executive actually was fired. An employee, put in this allegation against this executive, and now that executive's saying, hold on, I didn't do it, or whatever he's saying, and you guys fired me without cause or whatever, right?
Yeah. So they jumped the gun, and I see that quite frequently because they want to react. Like they know they're required to. The employer knows they're required to do something, so they need it for just a determination. Now you just breached his rights.
Sure.
As this is exactly, you breached his right. You fired him. What they didn't do is they didn't investigate. First, they didn't have their policies in place around sexual harassment and harassment, but they didn't investigate. So as an employer, you are really you have to.
Required to.
Thank you.
Yes, my pleasure.
Only two comments. You're required to do a thorough investigation. So, and not just taking one person's word that there has been a form of harassment or sexual harassment. And in this case, they didn't. So they took the other employee's word, they terminated, so therefore you breached his right. So both the accuser and the accused have rights. And then how to do that is doing a thorough investigation. Some organizations can do it themselves. Other organizations feel more comfortable bringing in a third party. And there are specialists for that to ensure that there's no bias being made and that the right questions are being done. And then it's really important to document the findings afterwards, and then make your decision based on that. So
inside of this too, so thinking about workplace culture, having this type of scenario in here, I can totally see why a company would want to react and just kick out the problem.
yes.
But how can an employee, like a company, maintain the culture as best as possible during this time? Can they put on like a paid leave for this individual?
Well, one, make sure it's very quiet, and in your meetings and your investigation is kept very quiet. Depending on the severity of it, if you want to send the individual home or not, but you got to make sure that you're not shaming that individual.
Sure, right? Like
well.
It's very sensitive.
It's very sensitive. So I would usually do the investigation with both parties separately, but still keep them in the office. Again, especially with sexual harassment and harassment cases, there's such a levels of severity. So I look at each situation differently.
Sure.
Do I need to send somebody home? Do I need to, put them on opposite sides of the building? Or can we have these conversations and figure it out while we're still both doing work? So,
Okay.
but I have experienced this many times where individuals have had false accusations, and when we've done the full investigation, the results has come back as non-justified claims. So that's very important so as an organization, to make sure that you do your investigation. And again, having the policies in place and doing the training. Because if you do get a lawsuit or a Ministry of Labor individual shows up, the sexual harassment now is also under Occupational Health and Safety Act and Human Rights Code as of 2016 September. So make sure that you have your policies and your training in place, because again, that will take some of the liability off you in fines to say, hey, we've done our due diligence. We told them, here's our training and here's our policies, and we told them that this kind of behavior is not appropriate. So now you've protected fines from the distributor.
Wow.
Yeah.
Anything you want to say about this one?
No, when you were mentioning the investigation cost, and I'd imagine there's a huge urgency on investigating any type of claim, and I didn't realize there was a third party that you can actually hire to investigate. So, okay.
You can, there's other firms, consulting firms that will come in and specialize in it. The Ministry of Labor sometimes may help out, but I'm always a fan, so not invite them into your house.
So somebody different for the webinar from the government. So.
No, but they can be quite helpful, and the ministry has a lot of tools out there to help you.
Sure.
Another resource is WSPS, and please don't ask me what that stands for, but WSPS.com. It's we're an organization who goes get all their health and safety training, like in a lot of different harassment training. They have different kinds of tools as well. So there are kits on how to do it.
Okay.
And so, just trying to think of like how to actually bring this all around, because there's a lot of information. So like, what are 3 things that maybe an employer should look at taking away from today?
I think, I say this over and over, ensure you're compliant. Ensure that you have your toolkits in place. And even if you have to be in a reactive mode now because you've been having business, your business has been running for years, just take the time and take the steps to become compliant and understand the different requirements in the Human Rights Code, the Occupational Health and Safety Act, and the ESA, and because it's overlapping and stuff. And ensure that your resources are Canadian and Ontario specific. Sometimes when individuals start Googling, you'll get directed, right? Click here for this and click here for that. And then I've seen individuals, we rolled out, here's our offer templates, here's our guideline, and it's all related to the state.
Sure.
Right? So be careful when you're Googling what comes up, and make sure that you're on an Ontario site if you're looking for specific information. And as well, though, focus on what type of culture that you want to. You talked about that a couple of times. In your culture, really recognize what type of culture do you want to have, and be proactive in creating that culture and creating the conversations and respectful workplace, and having those values and living the values if you want. Basically determining, this is the space that we're going to have in our workplace. And again, like I said, the last one is implement those tools, figure out what you have, what you don't have, find the resources, and, of course, we're always here to direct you if you have any questions, but putting them in place if you don't have them. Or making sure that they're updated. So a lot of organizations may, let's say 10 years ago, and they did their guidebook. Well, lots changed, right?
Yeah.
Look at Bill 148.
Yeah.
So a lot has changed over the last few years. So I would say definitely put them in place.
And something too, and I have a question, so I'll continue on forward with this. So, and not to like jump out of the scope of this, but when we were talking about this insurance before we started, you had not actually heard of it.
No, I haven't. So I learned something new.
And so just like, what, now that you've gone through this part of this conversation, like, what do you think about like having that as something?
I think it's amazing. It will be, and when you mentioned earlier a checklist, so we put into HR playbooks for organizations and our clients. So it will be on my checklist now in the HR playbook. You have this in place. Because I think it's amazing to cover it off, because again, the costs are so high.
Yeah.
So high. And the case that I talked about earlier, where there was this one clause in that letter and the agreement that avoided it, it ended up being a $24,000 cost versus a $4,000 cost, where the termination clauses were no longer ESA. It was now common law. So it went from 4,000 to 4,000.
Wow.
It was a one sentence.
Just one.
Right?
Yeah, and it's so challenging.
So the insurance, like the client, if they had that insurance, that would have paid for that.
Defending, investigating, and settlement as well. So, yeah. I think for me, what I want to add is, I know a lot of clients fear the application. I'd honestly say, don't fear the application that your insurance broker wants you to complete, again, because some of the questions are there to actually protect you. And it talks to a lot of correct points. Do you have written protocols? Do you have written procedures? When was the last time you actually talked about this with your staff, right? It just lists a few things, and it's a great place to start. The one thing that I wanted to put in at the last sentence was basically, by having an employment practices liability policy in place, you're actually ensuring that you have funds to grow your business and not defending a litigation claim.
Yeah, beautiful.
Yeah.
Thank you.
Yeah.
And Scott, I was able to read your question there as well. So here's Corette's contact information and Kita's as well. Fire them both off emails. But Scott, you were asking about companies that have policy in place, what can us? So what can us as a brokerage do? We support, and what can brokers do? And I think Corette was just starting to talk about something that she does offer, and it's this whole concept of the playbook and in her own checklist, right? So we are not HR professionals, and we love bringing in people who are HR professionals because they really look after our clients and can really help support. And so I don't know if you want to just speak more about what that playbook is.
We'll sit with an organization and kind of do an audit in the sense of what's in place, what's not in place, and we'll put our recommendations in. And we'll do it. And a lot of it is we do write a lot of handbooks and guidebooks for organizations. So, but that's always the first thing. Like I said, it's the foundation.
Absolutely.
So,
does anybody else have any other questions? We'll get into wrapping this up. Edith, do you have any other final questions, or Corette, do you?
No, I'm good.
No, I think I'm good.
So thank you both for taking the time to be on this webinar. Corette, you're a super invaluable resource to us, and we love that you keep coming out and participating. And Gita spends all day supporting our team, and so it's amazing when she can come out to a place like this and actually share herself with all of you as well. So thank you everybody for taking the time to be on this webinar. Again, their email addresses are here, so feel free to reach out with any questions you do have. And at the end of that, have yourself a fantastic day. Thank you.
Thank you.